You may have opinions about technology or events or other characteristics of the case based on your investigations and analyses. Sometimes, if your report is written after the opposing expert's report has been written and filed, you will be asked to formulate opinions about the other expert's report. When you do this, the goal is not to restate which of his opinions are valid, although you should certainly tell your retaining attorney your entire analysis of the other expert's report. Since you do not want to help the other expert or the other side, you should avoid commenting on any of the expert's opinions that are valid. However, your job demands that you carefully look at the other expert's work and comment on any errors you find in it. You can also note any invalid assumptions that he made that may undermine the validity of a conclusion he drew or an opinion he expressed. From the beginning, your job requires you to offer opinions that are true and explicable, and that will help your side of the case. When you help the defendant's side, the plaintiff's expert's report will appear first, and you will read that expert's opinions. While you may not have initially considered some of the opinions he may express, it will be your job to look at each one to determine if it seems correct. You must then carefully assess whether the opinion, correct or not, has been fully supported by the facts to which the expert refers and the procedures and methodologies followed by the expert. Your job is to read every word in the plaintiff's expert's report to see where he may have overstated the evidence, not just where he might have stated erroneous opinions. Overstatements are just as valuable as erroneous statements for an attorney that wishes to attack the credibility of an expert witness. Overall, you should understand as much as possible of the laws involved in the case. Of course, you're not a lawyer, but a key tactic is that while you should never express legal opinions, either in writing or in testimony, you should realize that understanding the legal elements of your case can often enable you to offer industry knowledge that will support your attorney's efforts. In my sample expert report found in the appendices, I express an opinion that the source code in question provided no competitive advantage to the plaintiffs. In trade secret litigation, the law defines the characteristics of a trade secret. One characteristic is that the secret, if maintained, must provide a competitive advantage to the holder of the secret. Because of my expertise in computer programming and also my expertise in the computer industry, I was able to conclude that the specific source code in that case had no competitive advantage to the holder. The code was available to the public on the internet, as well as available in books, so it was never a secret in the first place. Since it remained publicly available to anyone, no special or secret financial advantage existed for anyone that gained access to it. In this case, my industry experience enabled me to offer this additional opinion, which was of great benefit to my retaining attorney. But if I had not asked for further details about the law involved, I would not have been able to realize the importance of this, or to come to that extra opinion about the competitive advantage in the marketplace with which I was familiar. So, an important tactic: ask your attorney early on, what are the legal issues involved? What can he or she tell you about how your findings relate or can relate to those legal issues? But don't just stop there. You should do research on the internet or elsewhere about the legal issues so that you understand the issues facing the lawyers. In this way, you can focus your own technical efforts more intelligently.